specification, and count 2, improperly handling firearms in a motor vehicle, a felony of the 4th degree with an attached forfeiture specification. The state has provided discovery to counsel for the defendant and has made a written plea offer that would include the defendant pleading guilty to count 1, having weapons while under disability, a felony of the 3rd degree with the attached forfeiture specification. The state would move to dismiss count 2 at the time of sentencing. There is no recommendation on sentencing at this time, and the state would request a pre-sentence investigation report. Thank you.
Thank you. Mr. Hinton.
Thank you, Your Honor. We are in receipt of the plea offer in this case. We've also received discovery. Myself and the defendant are in the process of reviewing that discovery so that we can evaluate the plea offer and whether any additional pretrial motions would be warranted at this time. So we request that the matter be set for the court's normal series of hearings. We have executed a waiver of speedy trial, which I have here at the trial table. And I'd also ask to be heard on bond in the meantime, Your Honor.
All right. Mr. Beaver, do you understand what the offer is?
Yes, sir.
Do you have any questions about it?
No, sir.
All right, we're going to set this case for a jury trial March 11th at 8 o'clock. We're going to have another hearing on February 26th at 8:45. That will be your opportunity to either accept the offer or decline the offer. If you decline it, we'll go to trial on the 11th. But once you decline it on the 26th, absent some unusual circumstance, that offer will no longer be available. Do you understand that?
Yes, sir.
All right, Mr. Hinton.
Your Honor, as to bond, the initial bond was posted on this case. It was $5,000, 10%. The bond was increased, which would require an additional $2,000 to be posted. We would ask that the court modify that from 25,000, 10% to 15,000, 10%.
All right, Ms. Himmelman.
Your Honor, while this case was pending, the defendant had a new charge filed against him in the Painesville Municipal Court for domestic violence, and he did plead guilty to that charge. Based on that, as well as his prior criminal history, the state did request that the bond be reset at $25,000 and would oppose a reduction of that bond.
What's the date of offense on this case?
The date of offense on this instant case was October 8th, 2024. The defendant, a case was filed in Painesville Municipal Court against the defendant for domestic violence and strangulation. That was filed on November 20th, 2024. The defendant was given a personal bond, which was revoked the very next day, and then he pled guilty to domestic violence on, November 26th, 2024, and was given a 60-day sentence.
When was the bond set at $5,000?
The bond was set at $5,000 in this case on October 8th, 2024.
Okay, so while he's on bond on this case,
Correct.
when the subsequent case occurs?
Correct.
Okay. And when was the modification of 25?
That was done at arraignment, Your Honor.
Okay. I'm not quite sure why there was any bond, since there was a violation of it, so the motion to modify the bond will be denied.
All right.
Oh, headache.
All right, you all are still requesting your jury trial?
Yes, Judge. I believe we were actually set to go on Tuesday. Everything got messed up this week with the snow and ice. But yes, Judge, I believe we were set to go on Tuesday.
Yes. And how long do y'all expect this trial to last?
On the evading, 2 days.
I agree, Judge. 2 days.
All right, Ms. Ferguson, I need a jury trial setting on Kruger. And they say 2 days.
I'm fine with that, Judge.
All right. If something opens up sooner, we'll have you brought over sooner.
So Judge, he is trying to make bond, which he has a right to. He has a case out of county in Guadalupe County, which they have him remanded. And as you know, it kind of gets messed up. Is there any way that the court could benchmark him back to Guadalupe? Hopefully he can resolve that case and it would, or at least deal with it, talk to the court, and it would help him immensely as far as making bond on this one.
All right, if they want to send something to us, do you know what the charges are in Guadalupe County?
I'm not there, I just want to be.
UUMB, yeah.
Well, they'll have to send something to us.
I'm gonna call them again. They're not as responsive to me, and I'm also trying to, I think he's entitled to an attorney over there as well, but
Yes.
they're doing the thing since he's not in custody, but it's like a catch-22, we're stuck here. Let me kind of pester him again and see if we can get him, because I think really it's one of those, if he goes back in 2 or 3 days, he can have something figured out, and then he'll be back before the end of the week.
All right, and could you all make sure that the court has the acknowledgement of discovery?
Yes, Judge. We did one, but I'll be happy to fill out another one as well. if we
Right.
do.
Judge, may I say something?
Sure.
For the record, if the state isn't ready, they haven't been ready since August, ma'am.
Oh, no, it's not that the state is not ready.
No, ma'am, but I'm just tired of hearing, I don't know what other word I could have to say, but, we keep seeing separate juries, so if they're not ready, can you put a dismissal for next time we see?
No, well, let me just tell you the way it works. I'm only one person. Everybody is only one person, right? So I'm putting you down as, according to the coordinator, the earliest date I can put you in for jury trial. What I can tell you is there are other people who may be ahead of you because there are a lot of murder cases that have been set. And even though, even though that you've been in trial, in jail for a long time, and I will tell you, I consider being in jail 1 day or 1 hour is a long time. But the problem is I can only try one case at a time. Although one time in this court, we did try 2 cases at once. Your attorney remembers that. But I only have this one courtroom. I only have one jury room. And if your case is set for March 4th, and there's somebody else at the jail, and their case is set for March 4th, and their case is older than yours, their case is going to go before yours. That's just the way the system
I
works.
understand that, Judge, and I want to rewind myself, say, first of all, apologize for you haven't seen the orange, and Happy New Year. But at
Yeah.
the same time, I just, I've been 4 or 5 times, I've been 3, 6 times maybe now, we're separate jury, I just
Mhm.
want to be set free already, Judge.
No.
I have a
I mean,
family,
here's
I
what,
lost my car, I lost.
but what I'm telling you is, it is set for jury trial. But what I want you to understand is that there are other cases that were set for jury trial. For example, if I were to go through the calendar and say, okay, I'm going to only set one case for jury trial, then guess what? That would mean that you would go. But if you decided to work something out and for good cause, there's a reason for me to accept your plea, then we will have that entire week with no jury trials because nobody else would be set. So you're not the only person who's set for March 4th. They're telling me your case would take 2 days. Now, if you all want to do a bench trial, I can take you next week. So, well, no. That's something
4 or 5 years.
Here's the thing. Let me just tell you. A bench trial is something that you need to discuss with your attorney. And let me explain something to you about bench trials. What that means is that I hear the evidence. And what I can tell you, here's the thing. If the state presents evidence and they prove their case beyond a reasonable doubt, you're going to be found guilty. Wait a minute, stop. If they are not able to prove their case beyond a reasonable doubt, you're going to be found not guilty. I've had bench trials in this court where people have been found not guilty. I've had bench trials when they've been found guilty. Your attorney will explain to you what a bench trial means. And if you all want a bench trial, then I can see you next week. But discuss it with your attorney, not with me. All right.
Thank you, ma'am. I've been out 4 or 5 years, ma'am, and I just want to
All right,
protect my
so-
life.
All right, so here's the thing. You hadn't been 4 or 5 years on this case.
No.
No,
I'm talking
that's-
about freedom.
All right. Okay.
Being good, you know.
Well, discuss that with your attorney, deputy, if you allow them to discuss whether he wants a bench trial or not.